we can say that Section 439(1) confers special powers on the High Court or the Court of Session in respect of bail. Unlike Section 437(1), there is no ban imposed under 439(1) against granting of bail to persons accused of an offence punishable with death or imprisonment for life. There are no such restrictions under Section 439(1) as are there under Section 437(1). Section 437(1) applies to a magistrate's court. 439(1) applies to a court of session or a high court. A new subsection was introduced with effect from April 2018, subsection 1A to section 439, which makes it obligatory for the court to ensure the presence of the informant at the time of hearing of the bail application in respect of the earlier specified 4 offences. So, in respect of offences under 376(3), 376AB, 376DA, 376DB, a notice has to be given to the public prosecutor, and also presence of the informant or any person authorized by him must be ensured at the time of hearing. Subsection 2 of section 439 contains a provision for cancellation of bail. A high court or a court of session has been empowered to cancel a bail which is already granted by any person, any court, any authority under this chapter. And the person released on bail may be ordered to be arrested and he may be committed to custody. Similar power is there to a court of magistrate under section 437(5). The difference between these two provisions is that under 437(5), a magistrate can cancel the bail which was granted by him. Under that subsection, he cannot cancel a bail which was granted by a police officer. He cannot cancel a bail granted by any other court. But here, under 439(2), a court of session can cancel a bail granted by a police officer. He can cancel a bail granted by a magistrate's court. Similarly, a high court can cancel a bail granted by a police officer, by a court of magistrate, or by a court of session. Let's see the law on cancellation of bail as propounded by the Supreme Court in Delhi Administration versus Sanjay Gandhi in 1978. What is the law on cancellation of bail? The power, as we have seen, is available to a court of session and to a high court under section 439(2). An important observation made by the Supreme Court in this case is this: rejection of bail when bail is applied for is one thing, cancellation of bail already granted is quite another. It is easier to reject a bail application in a non-bailable case than to cancel a bail already granted in such a case. So there is a big difference between rejection of bail application when it is applied for the first time and cancel of the bail already granted. Cancellation of bail necessarily involves a review of a decision already made and can by and large be permitted only if, by reason of supervening circumstances, it would be no longer conducive to a fair trial to allow the accused to retain his freedom during the trial. There must be supervening circumstances, circumstances which were not there at the time when the bail was granted, circumstances which have cropped up later. Only on the basis of such supervening circumstances which render a fair trial to be not conducive, cancellation of bail can be permitted only in such a situation. Now, one normal ground which is taken by the prosecution when it applies for cancellation of bail is that prosecution witnesses have turned hostile at the time of trial. The question before the court in this case was whether the fact that prosecution witnesses have turned hostile can by itself be a ground for cancellation of bail. The court says no. Just because prosecution witnesses have turned hostile, that by itself is no ground for cancellation of a bail which has already been granted by a suitable authority. There may be many reasons for a witness turning hostile. The court has given two reasons here. First, a brother, a sister, or a parent who has seen the commission of crime may resile in the court from a statement recorded during the course of investigation. A brother, a sister, or a parent may turn hostile at the time of trial, but this happens instinctively out of natural love and affection, not out of persuasion by the accused. The accused may have no role to play in such a person turning hostile at the time of trial. This happens because the witness has a stake in the innocence of the accused and tries therefore to save him from the guilt. Similarly, an employee may, out of a sense of gratitude, oblige the employer by uttering an untruth without pressure or persuasion from the side of the accused. So here also the accused may not have any role in the employee turning hostile. And therefore, it can be said that in every case where a witness has turned hostile, it cannot be said that the accused had a role to play and therefore his bail should be cancelled. The objective fact that witnesses have turned hostile must be shown to bear a causal connection with the subjective involvement therein of the respondent, that is, of the accused.